Well, good afternoon. Can you hear me all right? We got the volume up a little bit higher. This will be the Thursday meeting of the House Judiciary Committee, and we've got 3 items on for consideration this afternoon. I'm going to bring up Senator Strickland, and I think the chairs need to be rearranged. I didn't realize they're out of order. If you would pull them around, and I think you want to bring up Alan with you. Mr. Cleveland.
Mr. Cleveland.
Why don't you come forward since we'll deal with Mr. Senator Stone's bill first, if you'd like. We're going to be considering Senate Bill, 194, which is LC 298013 ERS. And Senator Strickland, we're pleased to have you join us today.
Happy to be here, Mr. Chairman. I was coming to present another bill, but my chairman in the Senate now stepped out and told me to handle this, and so I'm going to bring to you Senate Bill 194. It's a really good bill. I think y'all already made some changes to it. He's very happy with that, and I think if you have any questions, Adam here can answer.
Yes, sir. Well, why don't you introduce your guest with you today?
This is Adam Cleveland.
That's right.
That's all you know, right?
That's all I know. He looks very capable. He knows a lot about garnishment. I think he testified in the Senate to us as well.
Why don't you lead out and tell everyone who you are, Mr.
Sure.
Campbell.
Thanks again. I was the creditors representative in the 2015 task force that Chairman Wendell and Chairman Stone did for the garnishments rewrite. I represent the Georgia Creditors Council, have several bank and financial institutions as clients where we process the garnishment answers and also perform garnishments, and so we're pretty familiar with the new law and the changes that are proposed here.
All right. Well, why don't you be the one, if you will, to go through and talk about the changes and what's being done and why it's necessary.
All right. So Section 1 is a change to the making of the affidavits that are now the kind of inception process for garnishments in Georgia. The clerks of court brought to our attention that it sort of asked them to be a gatekeeper, which may have exceeded their kind of job descriptions in most cases, and so there's been an amendment to that to make it so that a properly executed affidavit handed to the clerk of courts will now result in a summons issuing, and the plaintiff will take the risk of liability for any improper execution.
Where the law was asked them to approve something, they're really not in the place to do that. They're more ministerial in their services, and so we decided that's really unnecessary.
I think all of us practicing lawyers and the clerks felt that way collectively, and so that seems like it will work out well.
All right.
Section 2 corrects somehow amongst all of us in the task force and the rewrites the calculation of the total amount of exemption at minimum wage for a period of 30 hours a week was slightly wrong in our code, and so this corrects that, and then also helps to give the way to calculate for periods that were not 1 week, so that a person can have the right exemption if they use our code to try to do the calculation themselves.
Okay. That was a correction.
Yes. Section 3, also more or less of a correction. Our intention through the task force and in the new law was that the forms for producing a garnishment would be more or less mandatory, that we separated the summons for garnishment at a financial institution from the regular garnishment and the continuing garnishments. In this case, there had been some folks who'd come forward and tried to use the language in this subsection 2 of 1847 to say that the entirety of the summons of garnishment at a financial institution was not possible when it was a garnishment for wages, which is what a continuing garnishment seeks. What was intended was that the form not be used.
This dealt with the financial institution, and what you had was some people who were employees of financial institutions who were being garnished as employees. We're trying to raise the question, you can only garnish me for one time because we're a financial institution.
In fact, they were trying to say that you couldn't do it at all because the summons itself was what was prohibited, and this clarifies that no, it's just the form
bankers.
for the account type of garnishment that is being prohibited.
Section 4.
So subsection 4, this does a couple of things. Or actually, is that in subsection 6? Let's see. Yes, subsection 4 has got a fallback provision for when we send note in the garnishment. The defendant is not a party until or unless the defendant actually files a claim into the garnishment, but they are due statutory notice of the garnishment, and that is done under the new code by certified and regular mail to the current known address. but it provides a fallback because, of course, occasionally that address is wrong or you can't locate the person. And in the old code and in the new code, you could send that fallback by regular mail to the address where they were served with process in the underlying action, as long as you're willing to put forward an affidavit that would say that you looked and couldn't find the person in state, that you performed some mechanism for due diligence, and then that original address was satisfactory. The problem we found was that there were folks who did not fall within that fallback provision. So a person, for instance, who had been a bankruptcy debtor and you'd gotten a non-dischargeability judgment, so a person who actually committed some form of fraud in the process of owing a debt, didn't get served with process at any point leading up to their judgment, and therefore, if they simply moved and you couldn't find them, no garnishment you proceeded against them could actually be valid because you couldn't get anything that satisfied the notice requirements. So this closes that loophole by allowing that a person who now accepts service in the action in the judgment or identifies their residence in the judgment, those two locations are added to the list of places where a regular mail can go after failure of other methods or upon due diligence and attempts to find the current address failing. And of course, it also removes the language that says to the satisfaction of the clerk of court, because again, the clerk of court doesn't want to evaluate the affidavit that you file about your due diligence efforts to locate a current address for this person in the garnishment case.
Okay. So Section 5, again, just the need to clarify the time frame.
That's right. It was just a question brought by some judges that because the sentences in that section were separated, one sentence operated to say that a garnishment proceeding based on an affidavit would dismiss in 30 days if there weren't funds or a new summons issuing, which would be almost every single garnishment. And so to avoid that, the addition of after 2 years is clarifying the intention. And Section 6 has got two distinct parts. In the shortest part, if we skip a page to page 4, this would be line 99, it protects garnishees who may be traversed by a plaintiff on their answer. In the old code and in this code, it was written probably improperly from what we intended, but that was just how it had been for forever, that the judgment against a person found wrong in their traverse of an answer would issue for the amount paid into the court and for the amount not paid into the court. But realistically, that's kind of a double liability for a party who may have properly paid funds into a court with just a question of whether they belong there or not. And so this clarifies that a judgment should only issue against the garnishee for amounts that were found owed to the garnishment but were not paid into the court already.
All right.
And then moving back to the original part of this, on line 75 and also in lines 104 through 108, it distinguishes that a claim by a garnishee or by a defendant can be brought on the basis that there is some other party owed the funds. The intention was that they could, if they had other creditors or someone else, like a joint account owner, they could identify to the court that existed, and there's a provision in the rest of the code section that allows for notice being sent to that party. But the problem we'd run into was that many defendants had stepped up to the court and purported to represent the interests of that other party without the party present. And of course, it's not great when that happens with a so-called co-account holder. It's impossible for the defendant to represent their own, other judgment creditor at court in their garnishment proceeding with one creditor. And so this clarifies the defendant cannot do that themselves. The rules of standing still apply, and therefore the party in interest must actually appear on its own.
And the last section is just to clarify the form that's being used, where we had a need to add some language to clarify
The
that
exemption.
form exemption.
Yes, it changes the number so that the defendant who receives this notice sees the correct number as exempt.
All right. Well, thank you. Thank you, Mr. Cleveland. Any questions of either the presenter or our guest, Mr. Cleveland? Everybody seems to be understand. You do? You got it? Okay. Thank you.
Thank you. I appreciate that. I tried to listen. I know I came in a little late, and but the gist I get of it, and I think you may have said this is cleanup.
Yep.
There's nothing substantive in here, no substantive changes to what we did a couple of years ago.
No, nothing particularly partial. It's just fixing the mistakes that we inadvertently left in there or created by the language we chose.
And Senator Strickland is assuring us of that as the sponsor. Is that what I understand?
That's correct. And of course, Chairman Stone also made the representation to me.
That's correct. Thank you.
Thank you very
All
much.
right. Mr. Dwyer.
Thank you, Mr. Chairman. On page 2, line 54 and 55, which was tweaked a little bit after our subcommittee meeting, it says identified as his or her residence any pleading and action resulting in the judgment. I'm just wondering, could a plaintiff identify someone and that be an inaccurate address?
As I mentioned in our subcommittee
Yep.
hearing, it says in subsection big C, little I, to be sent to the defendant, in which the defendant, and so it's the defendant is the subject antecedent to that subsection Roman numeral 2. So the defendant identified as his or her resident is in any pleading in the action resulting in the judgment.
Okay.
Yep. What we do is have council, let's say council redo this part here, dividing it up by those 3 subparts,
Thank you. Thank you both for that.
or 4, I think, 4 parts, yeah. No, 3. 3, 1? No? Okay, that's what they did. Got a C, I, and then a number 1, number 2, number 3. Okay. We're set.
Right.
Anything further from members of the committee? Is there anyone else in the audience who wishes to address the committee on Senate Bill 194? If not, we'll close all further public comment. The bill is now in the breast of the committee. Do we have any motions? Chair accepts the motion do pass. Is there a second to that motion? It has been seconded. Any discussion on the motion? I know, get to it. We have a due pass of Senate Bill 194 as a committee substitute. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. Thank you.
Thank you all.
And you can remain seated with your next bill, Senator, and that will be Senate Bill 436.
Thank you, Mr. Chair. Members of the committee, bringing you Senate Bill 436. This bill is the result of a couple years worth of work from our probate court judges council, and they came together to look at our current practices in probate courts under the code and try to make sure we're codifying current practices. And I'm going to go over, if you'd like, Mr. Chairman, the substantive changes we're making.
Yes, sir.
Which is very little. The first section of the bill, Part 1, Section 1-1, is simply dealing with new judge orientation. It's confirming how we currently have the practice. It's not offered every single year. It's making sure that as soon as you're a new judge, you actually get your training the first time that it's offered. We see more cleanup in Section 1-2, changing the word person to individual, a lot of cleanup there. The next substantive part we get to is when you get into Section 1-7, and this is where we actually are raising the bond amount that you have to have as a probate court judge from $25,000 to $100,000. It's been some time since that was raised, and so we're making a change there, raising that bond amount in Section 1-7. The other big part we're doing here, currently under law, if there's a vacancy in a probate court for a probate court judge, the associate judge would just step up and finish that term. And so you could have a scenario where you have a probate court judge and starts their term, and then the next day the associate judge could be taken over and they'd fill that whole term. We instead, starting in Section 1-10, are setting up a special election similar to how we are elected. And so if there's a vacancy, there'll be a special election instead to fill that term, so the voters get to choose who takes that position. The associate judge would still fill in until that special election is done. Outside of that, Mr. Chairman, the rest of this bill is all cleanup language. The only other thing I will point to before I get to the part that you guys added in the subcommittee I was not at, so I may let someone else address that last piece. But we also have under Section
Way at the end.
1-31, we're adding the requirement that any objections to a ruling by the probate court judge would actually have to be verified. Right now it says it shall be in writing. We'll make that also be verified. I think a lot of courts are already basically requiring that, but that's one of the updates we're putting in this bill. Outside of that, Mr. Chairman, I just got the substitute for the last part. There's a little piece I think that you may know a little bit about that was added at the end of the bill.
Part 3, That was a bill we had that didn't get all the way through, Ms. Oliver's bill, and we've added that on here. Ms. Oliver, you want to speak?
It's part 3 on beginning line 683 is House Bill 738 that came through this committee that deals with aftermath of a case, Ray versus Stevens, about who may probate a will, file a petition to probate a will. And this expands the definition of interested party slightly to make sure that if there's a creditor out there who is owed money from the estate, that the creditor may be defined as an interested person. And there was no objection to the probate council to this matter being added to their bill 436.
That's correct.
That's good. Any further questions of the presenter by members of the committee? If not, no one else in the audience wishes to address the committee on Senate Bill 436. If no, we'll close off further public comment, and the bill is now on the breast of the committee. The chair will entertain motion.
You pass.
Motion is due pass with a second. Do we have any discussion on the motion? Any further amendments to the motion? There being none, the chair will call the main question, which is due pass Senate Bill 436 as a committee substitute. All in favor signify by saying aye. Aye. Opposed, like sign. That motion is carried. Thank you.
Thank you, members of the committee.
Who's the House sponsor going to be?
This is Representative Fleming.
Ms. Representative Fleming, all right.
Thank you.
Yes, sir. At this point, we have the next bill under consideration. Let me also mention we have Judge Hamrick, former senator, and glad to have you with us today, Your Honor. Any other judges in the audience? I had Dusty Hightower, but he hasn't appeared yet. We know whatever happened to Dusty.
Kind of like old days.
He
works today and takes the day off.
That's right. He just told me he's going to be down here, right? All right. Well, we are grateful to have you with us, Judge. Always a pleasure to see you.
Thank you.
Good friend, years past. I'm going to, at this point, turn the further hearing of the committee over to Representative Fleming, and I'm going to be presenting Senate Bill 373. I'm gonna move over. Yeah. I'll tell you what I want to do. I want to call up the law enforcement. So he just tell me the process. Okay.
Not sure what's right there. I got a little vodka in mine too. All right. So we have in front of us Senate Bill 373, and I'm going to ask Chairman if he will present that to us.
Yes, sir.
Tim?
Thank you, Mr. Chairman. First of all, a little background. This is a Senate bill, but it did not come over this way. The bill, for benefit of the members of the committee, came as a bill creating a new judgeship in Cobb County. And due to some misinformation, we'll say it came out of Cobb County about the filings that they had. We always operated, you know, in the past with a recommendation from the Judicial Council for the creation of judgeships. And with the mistaken information, the Judicial Council had recommended previously the creation of a new Superior Court judge for Cobb County, and withdrew that recommendation during the time we were already in session. This was a bill that was brought by Senator Tippins of Cobb County, and he asked the bill to be stopped. So we're using that bill for what is now a purpose of bringing before this committee a new statutes dealing with what we generally refer to as hate crimes. Georgia is one of, I think, let me have my list. We have been given to everyone on your desk and folder is a list of the states, and certainly our sister states, which have enacted over the previous years hate crimes. I think some of the pages. Yeah, it's two sections. This one? Okay. You see from Alabama, Florida, Georgia doesn't have any, Kentucky has it, Mississippi has, North Carolina has, to my surprise, South Carolina doesn't have, Tennessee has, and Virginia has. And really I say surprising, South Carolina, because of what they went through a while back with the shootings in Charleston, which was certainly a hate crime. And shortly after that, we had a situation in Georgia that was prosecuted over in Douglas County that was also a form of hate crime. And the people, even though we did not have a state law dealing with the questions about what may constitute hate crime, I know the prosecuting attorney, Brian, lost his last name. Fortner, thank you. I lost his name. Beg your pardon. Did an outstanding job, and the court imposed stiffer penalties on those people as a result of their conduct, which I believe certainly constituted hate crime. I go back. I lived during the '60s. I was a time, I became of age. I worked for a bank initially, and I remember being downtown, Mr. Chairman, and going to places in the downtown area where there were being protests at that time, and being aware, conduct of people that involve hate of one human being over another. And I look back and, frankly, feel some shame I did not step out more at that time and take some action. But be involved early years, starting a career in banking, and think, well, I don't want to do something that may cause a problem there, so you sort of see it happening. And although you're not totally ignoring it, you're not really caught up in trying to correct conduct of people. I try to live by, and always have, what I call the golden rule. And that is treat every person that you want to be the same way they treat you. And I think that is really the principle that's, I hope, has guided me all my life with my conduct against two others. So we had a bill brought this year by my dear friend, Ms. Hanson, that went to another committee. Unfortunately, we did not get very far with it. I was a co-sponsor with her on that bill. And I felt it really is a time that Georgia speaks to this issue about what is going to be unacceptable by the way one person treats another with involving criminal conduct. Now, it doesn't mean you can't sit there and say something bad to somebody, but if you also do something that rises to the level of having criminal conduct involved with it, such as a battery of someone or destruction of property, or even murder of someone, those things which motivate an individual by their hate for the sections we have here. And I want to read the language briefly, if I might, Mr.
Yes,
Chairman.
absolutely.
We use the same language throughout the bill as to all statutes dealing with either conduct against a person or conduct against a property. Some are misdemeanors, others are felonies. But in all cases, we recognize that a person who is conducting themselves with this intentional act of hate against someone because of their perceived religion, political view, race, national origin, homeless status, or sexual orientation shall, upon conviction thereof, be punished as for a misdemeanor of a high and aggravated nature. And I go back to look at all the sister states surrounding us, and you see most of these states use something similar as far as the basis for their statutory language to prohibit this type of conduct, and is actual or perceived in many cases what they use. I've had brought to my attention after drafting this up some question about the language that talks about a person's political view. Now, realize we're not encouraging by this language that there be people of an extreme view, say, encouraged to use their extreme language. The thing we're talking about with the political view is that if you have a political view and someone is of an extreme belief otherwise, and they, again, first of all, commit a criminal act against you, then there could rise to that conduct a prohibition which is brought out by the language of this bill. But we'll hear more about that, I believe, during the course of the people who want to talk to the committee today, Mr. Chairman, about the bill. I will, at this point, terminate my conversation and statement about it and allow the chairman to have others come up and speak on the bill, if you like.
Mr. Chairman, would you like to take questions from the committee first, or would you like
I'd be glad
have a
to.
particular witness come up first?
I can go ahead and take it now. Leave it up to you, Mr. Chairman.
What's your preference?
I'm fine. I'll take conduct.
Any questions of the chairman? 14? Mr. Kelly?
Thank you, Mr. Chairman and Chairman Willard. As I'm looking over the documents that we have here before us today, and we talk about our sister states and what they do here, I noticed that several of them, almost half of our surrounding states that have this, have in place protections for peace officers and first responders. And I don't think there's anyone that's under attack more in our community than law enforcement right now. And so I was just wanting to have an understanding of why we left them out of this measure.
A good point. And we've already, and I think I'll have the police officers' addresses, we have already enacted statutory provisions about harsh treatment or conduct against police officers and law enforcement personnel, emergency medical personnel. We think, I do personally think, has covered that. But we certainly are open to consider it. But we have enhanced penalties as a result of someone causing damage or injury to someone in those roles.
Ms. Oliver?
Thank you for doing this. We've both been here a long time, and this is time, so thank you. I'm interested in the other states' inclusion of gender, and the fact that your draft does not include gender. And I wonder if you might be open to an amendment that includes gender.
I didn't include gender, Ms. Oliver, because I felt it was, I don't know how you determine the hate of someone based on a gender issue. And we do have special crimes address conduct, again, such as rape, so forth, that may come out of malice, we'll call it. But I'm certainly willing to listen to others' arguments on that point. Thank you.
Representative Dreyer?
Thank you, Mr. Chair. And Chairman Willard, I'm reading the book March about Congressman Lewis, and with my sons, my 7 and 9-year-old sons, and it's proud for me to be able to consider this legislation today and go home and tell them about this. And one thing when I think of gender, there was this Gamergate controversy. I don't know if you've seen that.
No.
There was a online harassment of women that were involved in programming video games, and it went over to explicit threat of violence and sexual violence against the women, and then folks were even their addresses were exposed. People were in front of their houses. But that was a situation where I believe, Mr. Chairman, there was violence against someone just because they were a woman in a male space, like programming video games. And I was wondering if that might shine some light on the use of gender here.
They may do so, and I think that's something we can ask the individuals who may speak to the committee what their comments and thoughts are about that.
Is that Representative Bruce? Go ahead. Pull your mic to you, Representative.
Mr. Chairman, I too want to say that I am really glad to see this legislation, and I'm glad it's in our committee because this is something that I really want to see happen. I do have one question around the assertion of political view, because I'm trying to visualize when that would be applicable, when you have people who are expressing how they feel about a political point, and unfortunately sometimes it does end up start out one way and end up another way. We've seen that all over the country with the current president, and when he was campaigning, and even now. And I'm just trying to see when that would be applicable.
If I might try to form an example of that, would be if you had let's say, a rally of Republicans or Democrats, and then you had one of these extreme groups come in and attempt to disrupt that meeting, and by their conduct do something that is criminal in nature, such as a battery on individuals, striking someone.
Mm-hmm.
Then it could be perceived that their conduct grew out of their religious belief, and they have caused harm to someone for that reason, as a way of trying to inhibit that individual expression of their beliefs.
Okay, so it would be a physical altercation. You know, I guess sometimes what you end up with is one person incites the violence and another person actually commits the violence. And I guess that's what I'm trying to put my arms around. You get somebody that's standing up there, you know, riling the crowd up.
Well,
but that person did not physically touch anybody.
right.
So that's where I was trying to.
I think you'd have to have the individual who's causing the criminal conduct involved as a part of saying that that person is now, through their beliefs and having injured someone, doing so as based on their political viewpoint. Now, someone who's giving the talk, arousing the crowd, I don't know if it could, maybe let the prosecuting attorneys talk about that as far as how far it could stretch. Inciting, you might say you're inciting someone, so perhaps it could be considered to be a chain of events involved with it and could bring prosecution.
Okay, so we're going to leave that one to the judgment of the
Yes, sir. I
prosecutor.
think it'd be a good idea.
And we've got several people signed up to speak, and it might be a good question later on, Representative. Okay. Any other questions right now of the chairman? Mr. Chairman, let me ask you a couple of questions. As I went through the sections of the bill, I went through and highlighted what we were doing. We've got battery, we've got assault, damage to criminal property. When you get over to page 3, section 1.8, 1-8 rather, we're repealing something there. What are we doing right there in section 1-8?
Let me see what we've got here. 'Cause
Line 83. It's probably something to activate, I'm assuming, the rest of the bill, but I was
I wish
wondering
Ms.
what-
Travis were here. No, I'm sorry,
Miss-
you did
Miss-
this, didn't you? I'm sorry. 41?
Yeah, she originally did with the original that I did.
Okay.
That's the.
What mic number are you, Mr. Talbert? Well, just
Well,
press a button and I'll know which, there you go. All right, go ahead.
That's the old hate crime, well,
Ah, that's it.
It's the old what, I'm sorry, Mr.
the
Talbert?
old hate crimes law.
That was clearly unconstitutional.
Okay.
It's just retelling
Yeah.
those laws that we are enacting.
So we're just cleaning up right there.
Right.
Is that the same thing with 1-9, 1-10? On the next page, page 4, section on 89 through 94?
Yes, that's all in that,
Yeah,
17, 10, 17,
18,
18, 19, right.
Okay,
It
so,
was 3 total sections items. It
And-
dealt with hate crime.
okay. So, and then my next question, Mr. Chairman, is about part 2 on line 97, page 4, section 2-1. What are we doing right there?
this is, part of the juvenile code,
Yes, sir.
and this is dealing with I believe the action of a juvenile that is also then rises to the level of being, a criminal conduct, but also, tied with the conduct of hate.
Is that right?
Correct.
Okay,
that,
absolutely.
Classifies in, the code section 16.5.21, which is under section 1.2, 1-2, that classifies that as hate crime as a class A designated felony under the juvenile code.
So we're basically taking what we're doing for adults and doing the same
Yes.
thing with juveniles. Is that an overstatement? Is that correct?
That's correct.
Okay.
That's that one area, yeah.
Okay. Ms. Hanson, did you want to comment further?
I did just want to kind of echo Representative Wright and Representative Oliver about the need for gender to be in there, because then if we're leaving out gender, I think that we're leaving out any kind of sexual related offenses. I think that's correct.
Well, it's open for amendments, so certainly appreciate that.
Okay. All right. Is your mic on, Mr. Talbert?
It's red, yes.
Yeah, here you
Blinking.
Don't stop blinking.
go. Don't blink. Yeah. That's right.
You've broke it, Mr. Talbert.
What I'd like to do at this time, Mr. Chairman,
Yes,
is
who would
that
you like to call, Mr.
I
Chairman?
have invited several individuals with law enforcement here to talk about the bill, and if I might suggest, we start with them before we have the other public, but I've got, and they can
That's
come
fine.
up, I've got Mr. Pete Skandalakis with the Prosecuting Attorney's Council here today. If you would like to come forward, Mr. Skandalakis.
Good to see you.
Good to see you.
We see you more in judiciary non-civil, don't we?
Yes, sir, you do, but
Yeah.
it's
Good
a
to have you
pleasure
here.
being here.
Go ahead and introduce yourself to everybody.
My name's Pete Skandalakis, and I'm the new executive director for the Prosecuting Attorneys Council. I guess now that I'm into how many days
Don't
are
call
we?
you new anymore.
I'm not new anymore. And some people say I'm the new and improved version of Chuck Spahas, but somebody pointed out that's not a big bar to rise to. So. But I appreciate being here, and I've certainly enjoyed
And you
this.
also have a background.
I do.
District attorney for how long?
I was the elected DA for 25 years in the Coweta Judicial Circuit, which is a 5-county circuit. Carroll, Troup, Heard, Meriwether, and Coweta counties. I'm a prosecutor with 33 years of experience in the courtroom. So I bring to this table a little bit of prosecutorial experience. I come here in support of SB 373, as Chairman Willard has amended it, this substitute, to let you know that this is a good bill. It's a good start, that Georgia should be along with the other states, and we should not be an outlier on this matter. I'm also the son of an immigrant, and I was raised by multiple immigrants, and a whole family of immigrants that came over during the late 1940s after the Greek Civil War. So one thing I always heard at all our dinner tables, and I always heard at all our holidays, was God bless America and God bless the freedoms we have here. And one of the freedoms the Greeks were very proud of was freedom of speech. And this doesn't punish freedom of speech. Please be mindful that in order for us to use this hate crime legislation, which is an enhancing penalty, it's not an additional crime, is that you have to have a criminal act. And that criminal act has to be a simple assault, a simple battery, an aggravated assault, or an aggravated battery. So it's not a matter of punishing somebody for their views or their their willingness to speak out on a subject, because if anybody's ever been to a Greek party, you know they're all willing to speak out on any subject if they know something or not. So it's not that. It's about punishing a crime that's committed against a person for a particular reason, and that's simply because you have selected that person as a victim for that specific reason. And we do this all the time, Mr. Chairman. We have crimes in which a special category is the elderly. If a person is elderly over a certain age and certain crimes are committed against him or her, we have enhanced punishments. We do it with public safety officers. So this isn't something new or unusual. It's something that Georgia does routinely, has done. And as you well know from talking to Legislative Council, we had a hate crime statute many years ago, but it was too vague and too broad. And that's why the court overturned it. But prosecuting attorneys support this, the Solicitor Generals will support it, the DA support it, and we're glad to be here as part of this. I'll welcome any questions.
Questions of Mr. Scandalakis by members of the committee? Mr. Chairman, did you have something?
I do. Let me ask you, Mr. Scandalakis, do you see in your work, and have you as a prosecuting attorney over the years, seen conduct of people that had you had the ability through a statute of the state such as this been able to address the fact that they're doing the crime, their actions was based upon hate as outlined herein?
Chairman Willard, I have. Personally, I've seen cases in which we would have prosecuted using this statute as and including that element in it on an indictment when people are selected because of their national origin or their race. And sometimes they may be afraid to come to police. I know you spoke about Brian Fortner. Brian Fortner recently prosecuted a case in which members selected victims because of their race, and he successfully prosecuted that and would have prosecuted using this hate crime legislation to get the enhanced punishment. So I have seen it. I have done a survey of other DAs. They have given me examples of cases in which a homeless person was picked out because he or she was homeless and was victimized. And that homeless person would fear that the police would not take that case seriously. I've also was told of a case in which a gay person was selected because of their orientation, their sexual orientation. So I have seen it personally. I know my colleagues have seen it, and that's why we support this legislation.
Thank you, sir.
Other questions of Mr. Scandalakis from members of the committee? Mr. Holcomb?
Thank you, Mr. Chairman. One question for you in terms of, I understand the impact that the legislation would have in terms of the prosecutorial side for activities that have already occurred or crimes that have already occurred. Can you talk a little bit about whether or not you see this as having value in terms of deterring crimes in the first place? By sending a signal that this is something that can be taken.
You know, I appreciate the question, and when you get into deterrence, it's always a difficult question to answer and to measure. But I will tell you this, it does send a message, and it sends a message that that we're going to take these type of cases seriously. And if you're selecting someone just because you don't like them, because what they mean to you, then that message has to be sent that we'll take these cases seriously and we'll prosecute those cases. So is it a deterrent? You know, you'd like to think that our homicide statute, which is one of the toughest statutes in the nation, a mandatory 30 years to serve on your first conviction for life in prison, would be a deterrent. But I've been prosecuting cases long enough to know that when individuals commit these crimes, they don't often think of the deterrent value. They just want to do what they want to do at the time that they want to do it.
Other questions of Mr. Scandalakis? I have one.
Yes, sir.
The first item on the list, or the long list, is, I'm looking on line 21, is religion. So let me use that one as an example. Assume the defendant is Protestant. Assume the victim is Catholic. Assume the Protestant has a shirt on that says, "I hate Catholics." If the defendant hits, assaults the victim, has the defendant committed a hate crime?
If you could prove that he did so because the victim was wearing that shirt, which is a jury question beyond a reasonable doubt, then it would be something that you would have to allege in the accusation or the indictment. And obviously you would have the lesser included offense of battery and simple battery under that, and simple assault. So that'd be a difficult case to prove, but I think it was something you could charge that way.
So what we're getting to there is basically, if you as a prosecutor are going to enhance the charges, and that, help me with my words if I don't use them right, by citing the actions as a hate crime, you have to prove that
You'd have to prove it
as
with
a separate element?
it's an element within the offense that you're charged. So you would have to you'd have to be able to prove beyond a reasonable doubt that they selected this victim because of a certain, you would have to prove that the defendant's actions were based upon his or her not belief, but his or her actions were based upon the fact that the other person was different than they are. Yeah. But you could, when you charge that, you must take into account that you would also have, when you include that element in there, you also have the lesser included element that it's still a simple assault or simple battery even without that additional element that you're trying to prove. It has to be alleged in your accusation or your indictment.
In my example, if this was caught on video, the assault's fairly easy to prove, or at least you have very good evidence.
Yes, sir.
But the other count, the
Would-
hate crime, basically.
It would be difficult. It would
So-
be difficult to prove.
As a prosecutor, how do you try to figure that out? How do you try to figure out the mindset of the individual who has committed the hate crime? Is it by, I'm assuming you search for their actions, you go look at their Facebook page.
That's exactly
you see
right.
what bumper stickers they have on their car.
That's exactly right. You would go, just like they did in the Douglas County case. They went to Facebook. They started looking at posts. They started looking at what was said. They started looking at other actions. They interviewed other witnesses. So you would have to take all that into consideration before you decide how you're going to go about charging that.
Now, the defense would have to point out another fact, for example, that the guy who got hit was making advances on the other guy's wife. And that's really why he hit him, I assume, correct? In other words, if you did find out that this guy had a T-shirt that said "I hate Catholics" and he had bad things about Catholics on his webpage, then that is your prima facie case as a prosecutor.
Right.
And then the defendant has to say, well, yeah, I don't like Catholics, but I didn't even know he was when I hit him. I hit him because he was making eyes at my wife, or something different than the religion issue. Is that how that would work? In other words, I'm getting into how you prove
Not
the mindset
necessarily.
of an individual.
First of all, the defense doesn't have to prove anything. The defense could simply allege that the state didn't carry its burden. But if the defense does have a defense, obviously you would put that up. And not only would that be, then you're getting into this point where you're not only countering the state's case, but you're also trying to give the jury an opportunity to nullify the entire assault, which does happen at times.
Okay. Who is 13? Miss Oliver?
I just wanted, if I may, enter into this discussion.
Sure.
And I was just thinking exactly as you were, a barroom fight between two men, one of whom didn't even know what religions, it would not be a case to prosecute, but a demonstration where Protestants are saying, I have a right to be here, and Catholics are saying, no, you don't, or whatever the reverse would be a totally different context. And that's the purpose of the statute, is an identified assault. Assault you have to prove, and the identity of the assault victim is based specially on their status, which is different than the barroom fight.
Exactly.
All right. Mr. Holcomb? Sure.
My sense is that the application of this will be somewhat correct. Would you agree with that?
Yes, sir, I would.
And I'm looking
Absolutely. And again, just my poll of prosecutors, we have not had that many cases. That's correct.
Representative, what website are you looking at when you're talking about FBI? I'm trying.
FBI, their uniform crime reporting statistics. I looked up hate crimes and they have the numbers by state.
It's gathered by state crimes.
Yes, sir.
That leads into the question I had for you, prosecutor, is that, well, Mr. Scandalakis,
Okay.
is there a federal law that covers hate crimes?
There is a federal hate crime statute.
And so what is a federal hate crime? I mean,
And-
assault's not a federal offense, I don't think. It's
No, no, and I really am not that familiar with
I
it.
know you're not a federal prosecutor.
Yeah. Well, I'm just. It's very seldom that the FBI and the U.S. Attorney come in and take over those cases. So I am not that familiar with the federal hate crime statute.
Mr. Holcomb, this goes to also kind of what you were talking about. I'm wondering, I was about to ask the question, how often is this used at the state level? And what you're saying is very seldom, because that's a compilation of states.
Yes, they report the statistics, the agencies put from, and it has all the agencies that report, and they send them up for the overall statistical analysis nationwide, so you can get some sense of how frequently these are occurring in the WC. That could also be because we don't currently have any kind of statute, and so it may be just some judgment in terms of whether or not these are a crime as opposed to really defining whether or not they would fall into that category.
Ms. Hanson, you want to elaborate on that?
He's 100% correct. We don't mandate.
Oh, hold on, turn your mic on.
Correct. I was just going to say that Representative Holcomb is 100% correct, considering we don't have a definition for hate crimes right now. We have 6 agencies that are hypothesizing about what hate crimes will be, probably using the federal statute and applying it to that. But we don't mandate reporting, so they're voluntarily reporting to the FBI. The FBI would, if anybody's here from the FBI, would love for us to have a hate crime statute, so that we would have something to follow, so that we could report, so that they could accurately reflect how many hate crimes we actually are having and experiencing here in Georgia.
Are you a former prosecutor?
I do work at a DA's office.
Well,
I
yeah.
am also very hospital.
Well, you sound like you know what you're talking about.
Yes.
I know that you did care greatly about this issue, and I know you worked very hard on it, and I know your constituents appreciate that. So your passion, I understand. All right. Any other questions of Mr. Scandalakis? Okay,
Thank you,
thank you
sir.
so
Thank
much.
you so
Are you going to
much.
hang around?
Yes, sir.
I
I'll
could
be
see
here.
these law enforcement questions popping up.
Yeah.
I'll be here. Yes, sir.
Thank you so much. Who else?
Next, Mr. Chairman, I've got a dear friend of mine, Mr. Keenan, Vernon Keenan, with the Georgia Bureau of Investigation. He's their director. As Mr. Keenan works his way up, let me say I have had the pleasure and the honor of working with him in a number of years in the legislature and doing some things to help protect, for instance, the elderly and the people with mental deficiencies, and also children. So, Mr. Keenan, glad to have you here today.
Thank you, sir. Mr. Chairman, I'm Vernon Keenan, Director of the Georgia Bureau of Investigation. I've been around for 45 years at the agency.
You're new.
I have testified many times in support of hate crimes legislation for this state. And I'm here today in support of SB 373 with the approval of the governor. Now, my assessment of why this state needs a hate crimes law is based on my experience in investigating actual cases throughout the state of Georgia. When I was a young agent, one of the cases that I worked involved a African American man who was married to a white lady. They lived in North Georgia. 2 Ku Klux Klansmen broke into their house and attempted to stomp the African American male to death because he was married to a white woman. And that I don't even know that they knew his name or the name of his wife, but he was selected because of his race and the fact that they disagreed with the interracial marriage. I also had a case in Middle Georgia where we had 2 white supremacists that are riding around in Middle Georgia in the middle of the night drinking, and they decided it would be fun to burn down a 150-year-old African American church and to show the black community who owned the night. Now, we apprehended them, and when it came time for prosecution, the case was so egregious, and the state of Georgia did not have a hate crime, then we went to the U.S. Department of Justice and they adopted that case. Now, it's been my experience in this that when you have a hate crime, you have individual victims, but you also have the community that they're part of is also victimized, because you're sending a message not only to that individual who's selected because of their individual sexual orientation, race, national origin, on those areas, but you're also telling the other persons that they're also hated. We had a series of crimes here in Atlanta when I was a young supervisor here. We had groups of men riding around doing what they call gay bashing, picking out men at random who they believed to be homosexual and jumping out and beating them up for fun, selecting them purely because they're perceived that they were gay people, and it would be fun to victimize them. It's been my experience also that when we apprehend some of these perpetrators, they will tell you why they picked this individual. Because I hate blacks, I hate Jews, pick it at whatever. They'll tell you that. And so but the state of Georgia needs not to be one of the 5 states in this nation that does not have a hate crime. We train law enforcement officers on the seriousness of responding to a hate crime. When someone paints swastikas on the Jewish synagogue, that's not only vandalism. They're sending a message to the entire Jewish community. And when we teach law enforcement you need to aggressively pursue these cases, they then say, if this is so important, why doesn't the state of Georgia have a hate crime? And I don't have an answer for that. But I would like for that to change. I would like for this state to have a hate crime so that we can send a message to those persons who are going to commit a crime because they select a person, many at random, mainly because of the areas that we're talking about in here. I believe this is extremely important that the state of Georgia state that we're not going to tolerate this.
Good comment.
Thank you, Mr. Keene. Questions of our GBI director? Thank you very much for being here today. Can you hang around also?
Yes, sir.
Thank you so much.
One last person, Mr.
Yes, sir.
Chairman, Frank Rotondo, who's with the State Police Chiefs Association, is not here, but we have another gentleman. I'm sorry, I forgot your name. I beg your pardon. If you come up, please.
Thank you very much, Mr. Chairman. My name is Dwayne Orick, and I am. And say your name one more time. Dwayne Orick. Mr. Orick.
Yes,
thank
sir.
you. Just like the vacuum cleaner, right?
Yes, sir.
Okay, I
wish
got it now.
was. I'd be hockey.
Right. So, I want to thank the committee and the chairman for allowing me to come speak today on behalf of the Georgia Police Chiefs and support this legislation as introduced through as a substitute for Senate Bill 373. I know I don't look like it, but I've been in police work for 38 years, and I was a police chief for 23 years. And earlier this year, the Chiefs Association reinstituted a resolution that we had done a few years ago supporting the legislation to combat hate crimes. And it's a growing problem in our state, especially because of the personal nature of, and it's a critical because it's a personal attack on the individual solely based on their identity or their beliefs of who they are as an individual. We as association are committed to preserving the rights of all persons and victims, and we're opposed to the bigotry and the prejudice of any form. And we supported this bill earlier when it was introduced by the chairman and Ms. Hanson, and it had a little bit more inclusive approach I'd like to talk to for just a second, because some points were brought up a minute ago. But I want to personally commend the chairman and Ms. Hanson and the entire committee for taking this up and their tireless efforts to address this issue. But earlier divisions, you brought up an issue just a second ago about the number of crimes that are reported. It may be because there's not a mandatory reporting requirement to GCIC, and the second issue is
a need to actually train officers. Now, we understand for this bill is a compromise, and we're willing to support that, but those are also issues that we don't know because there's not real accurate reporting of what's going on. Because we do know, as Mr. Scandalakis and Director Keenan have spoken to, there are crimes that are based upon somebody's sexual preference, of their race or their religious beliefs. And so with that, I'll be happy to answer any questions.
Thank you, sir. Any questions of Chief Orrick? Thank you so much for being here today. We appreciate it.
Thank you very much.
Anybody else you like to call names?
Yes.
Okay.
That covers what I have invited, Mr. Chairman, of persons to address the committee. And I will close with this part of it, just saying I agree with Chief Orrick about the fact that we don't have in the bill some of the things that Ms. Hanson had in her bill. And I did that deliberately. I wanted to, first of all, put in place the criminal statute that we need in Georgia. And I think from there we can then build on, through his association, through the Sheriff's Association, through the GBI, the information necessary to start making the accountability of these crimes in Georgia. Training comes as a part of the top of these organizations coming down, and I know with the GBI we have provided resources for specialized units in the past, and I think that's something we would again consider through the appropriation means of doing it without having it first mandated in the law.
Okay.
All right. Well, we do have a list of several people that have signed up, so I'm going to start with that. Mr. Jeff Graham. Mr. Graham, welcome. Good to see you today.
Good to see you as well.
Please come forward, and happy to have you, and tell us who you're with, and we'd be happy to hear from you.
My name is Jeff Graham. I'm the Executive Director at Georgia Equality. Our mission is to advance fairness, safety, and opportunity for gay, lesbian, bisexual, and transgender communities throughout the state of Georgia. I do appreciate the opportunity to respond to this language today, and I must say that I do truly appreciate, Chairman Willard, your efforts to bring this very important issue into law here in the state of Georgia. It has been a long time coming. Many people have suffered because there is not a state hate crime statute on the books. Their crimes have not been fully investigated, nor reported, nor prosecuted. And I do appreciate your efforts as well as the efforts of Representative Hanson to bring this very important conversation to the legislature. I do have some concerns, however, about some omissions that are currently in the enumerated categories that were in the original bill that Representative Hanson had introduced, and that is specifically the lack of mention of gender and gender identity in that bill. Transgender individuals here in the state of Georgia are frankly some of the folks that are most prone to being attacked because of who they are. Those attacks, when they happen, have been incredibly vicious. 2 years ago, we were shocked to see two women violently attacked on a MARTA train. A MARTA train for being transgender. These women were attacked, they were stripped, they were taunted. A group of people stood around them and cheered people on as they did that attack. The Atlanta Police Department and the FBI was not able to fully investigate and prosecute because there was not a hate crime statute in Georgia and because there was not specific protections around gender identity to ensure that they had the support to fully investigate that. Those are the sorts of incidents that I hope we can avoid in the future. I do feel that the training, the reporting, collecting statistics are vital to the success of having a hate crime statute in Georgia, and we do feel that it needs to mirror the federal language so that there are uniform standards in Georgia as Georgia works with FBI to fully investigate, prosecute, and deal with these crimes.
Mr. Graham, in your example that you just gave us, you said these two people were beaten. Is that correct?
That is correct, yes. It was a very violent attack.
And you said there was difficulty prosecuting them for that assault.
They were not able to prosecute under the federal hate crime statute.
But they were able to prosecute them for assault.
They did for assault, but there was not the enhanced penalties. That was not reported as a full hate crime. And frankly, members of the LGBT community felt that our voices, our concerns, our experiences were treated less than others because of the lack of a hate crime statute that was inclusive.
Representative Beskin?
Thank you, Mr. Chairman. And Mr. Graham, thank you for coming today. In your example, if the proposed statute were amended to include just the word gender and not gender identity, because it says actual or perceived gender, then would the statute, in your mind, cover the situation you described?
It is less than an ideal situation. And frankly, the courts are still split on this to some degree. And that's why our preference, strong preference, is that it really needs to follow the federal language of gender identity in there. Gender is a good start in that direction. I would really defer to law enforcement officials to feel if they would actually have the impetus to ensure that there is training of law enforcement personnel on how to deal with victims of crime if they are transgender.
Okay, thank you.
Representative Dreyer?
Thank you, Mr. Chairman. Thank you for being here and stepping up and standing up for the transgender community. I have friends and constituents that are transgender, and they certainly deserve our respect and protection. Would you said the federal hate crime statute protects gender identity?
Yes, it's explicit with gender identity.
Okay, and how long has that been in place? Do you know?
That has been in place, I forget the exact year, I think it was 2010.
Thank you.
But perhaps longer. But
All righty. Thank you so much for being here today. We
Thank you.
appreciate it. Thank you. Allison Goodman? Ms. Goodman, welcome. Good to see you.
Thank you so much.
Please come up and tell us who you're with, and we're happy to
Sure.
have you.
Thank you for having me. My name's Allison Goodman. I'm the director of the Anti-Defamation League here in the Southeast region. First and foremost, I just really want to thank you, Chairman Willard, for bringing this bill up. As somebody on the front lines of anti-bias education and advocacy every day, your presentation was really inspiring, and it's really great to see this. We have been working on hate crimes legislation for a while, and we lead a coalition of 30 organizations that represent the diverse constituents of the community, who have been working with Representative Hansen and Chairman Willard, and we're very excited to see momentum forward on this. ADL is a 105-year-old civil rights and human relations agency, and our founding coincided with the Leo Frank trial, and so hate crimes has kind of been our bread and butter for 105 years, and we've been working on it since. We drafted the model legislation language that's been used and adopted in 45 states in the country in 1981, and we led the coalition that advocated for the federal hate crimes bill, and so are very familiar with this work. The current version of the bill narrows the underlying offenses that could be prosecuted as a hate crime, and it's a framework that ADL can support. We do have some serious concerns about some of the categories of groups, and we can't really support it in its current form. There are two concerns specifically that are troubling for us. First and foremost is the inclusion of political views. This inclusion would perhaps unintentionally give protection of the hate crime law to white supremacists, neo-Nazis, and other extremists. The inclusion of this term was likely based on a concern about persons being victimized for attending political events and rallies, but political view is a very broad term. And while political views and beliefs of white supremacists, sovereign citizens, ISIS, and other Islamic extremist groups are odious, they are nonetheless political in nature. For example, the Nationalist Socialist Movement, which is currently the largest neo-Nazi group within the U.S., characterizes itself as, quote, the political party for every patriotic white American. As a result, the legislation would unintentionally provide the protection of a hate crime law for persons targeted for criminal acts based on such extremist views. And this circumstance is not hypothetical. Last October, when white supremacist Richard Spencer spoke at the University of Florida, a neo-Nazi who openly wore white supremacist tattoos decided to walk among the counter protesters and was assaulted. While ADL in no way condones criminal victimization in any way, should such an individual have the protection of the hate crime law based on his white supremacist views. In good conscience, we cannot support a bill that gives hate crime law protections to the very types of persons who have committed some of the worst hate crimes in America. Second, we also, like our friend Jeff, have issues with the exclusion of gender identity. And just to give you a sense, hate crimes committed, bias-motivated crimes based on gender identity have been on the severe rise. In 2013, when the FBI initially started collecting data on gender identity bias crimes, there were 31 crimes reported. In 2016, there were 124 gender identity-based crimes reported. So we urge you all to include gender identity and to take out the political view piece, and then we will very happily support this bill moving forward.
Questions for Mrs.
Goodman.
Ms. Goodman?
Goodman, yeah.
I apologize.
That's okay.
I've got the point where if I don't put my glasses on, I can't read well.
No problem.
Questions for Ms. Goodman? Mr. Chairman, did you have one?
Ms. Goodman, I'm,
Sure.
and I'm understanding your concern, but I guess I'm trying to go back to the fundamental beliefs of free speech regarding anyone.
Sure.
I don't always agree with what someone says, and certainly white extremist groups would not be somebody I would look to follow. But there are several states that have enacted legislation which includes what they call political affiliation. I felt the term political affiliation was not the appropriate term, but political view would be what you're really talking about. Someone's taking a criminal act against them because of their view and not their affiliation.
Mm-hmm.
And I guess the question goes, you have to, as you heard the prosecuting attorneys and GBI talk about, you have to have first a criminal conduct against that person as a means of saying they now, because of their political views, have been attacked, and whoever attacked them, you're looking and saying they should be punished for their attacking someone because of their opportunities to speak about their political views, perhaps. Is that what you're opposed to? Is anybody's right to have a chance to express what their views are?
So we are huge proponents of the First Amendment, and free speech is very important to us, and we work with people every day on this issue and how to support the free speech while also kind of countering hate and defending against attacks against hate groups. And we see that playing out on college campuses, and we see it playing out in communities. In the case in Florida, for the example, we do not think that a neo-Nazi should be an attack on a neo-Nazi, let's say he was from the National Socialist Movement, should be categorized as a hate crime. That is problematic. Does that answer? We're not opposed from people.
Say that again. I want to make sure I understand you.
Sure. So the neo-Nazi who was attacked in Florida for submerging himself with the counter-protesters and who clearly distinguished who he was.
Sure.
We do not support the attack on the neo-Nazi for sure, but we do not think that qualifies as a hate crime. A hate crime is committed against somebody based on the basis of their identity, not on their beliefs.
And you think they weren't mad at him because of what he believed in?
This is also somebody who is constantly pushing hate and pushing hateful agendas.
Just like the other people that we're passing this bill potentially against do, correct?
Say that again?
You pick any of these groups down here, whether it be sexual orientation, national origin, race, people are hating someone in those categories.
Right. But those people in those categories, those victims, are not hating people in their act. They are being who they are. They are being true to their identity and being true to those immutable characteristics, the things about them that they cannot or should not have to change. Political view gets very tricky, right? Because we also then have to wonder about how we're going to distinguish between certain categories of views and not, and then we have to worry about unconstitutionality.
Mr. Bruce.
I think you are addressing the same question that I asked earlier. And I look at this, I grew up during a period of time when just walking into a restaurant or some place, caused the problem. But I think back to Dr. King as we look at this thing. Dr. King preached constantly nonviolence, nonviolence, nonviolence. But at the end of a lot of his speeches, people became violent, not because of him saying be nonviolent, but because of their hatred. And I guess I'm concerned with the political piece. That's why I asked it earlier, whether or not, somebody like Dr. King would have been, prosecuted or could have been prosecuted under this because of that. And that's why I was just looking for.
First.
Well, that's what's not clear. That's why I asked the question. Are we talking about somebody that incited the riot because of their speech, even though the speech was not intended to incite a riot, like Dr. King? Or are we talking about somebody who physically touches somebody else? And the answer to that question when I asked it earlier was it would be up to the district attorney or the prosecutor to decide.
Well, I think you've got to prove the underlying crime first. And so the answer to your question is, I don't think you could be prosecuted for that. You've got to commit the crime, and then the hate comes on top of it. To put it oversimplified, probably.
Yeah, but that's what I was just trying to get clarity on,
Right.
whether or not what are
question.
we talking about?
Good question.
Yeah.
Is that Dreyer or Welch? Representative Dreyer?
Thank you, Mr. Chairman. When I look through some of the hate crime statutes that do have political affiliation, California in 1976, District of Columbia enacted in 1989, West Virginia in 1987, Louisiana in 1997, Iowa in 2011. Do you see any trends on including political affiliation in hate crime speech? Maybe it happened, it's less likely to happen in statutes enacted more recently?
I think that's correct. I think statutes that are enacted more recently are following the federal statutes model. And so gender identity is kind of a basic and political affiliation is not.
Thank you. One last question for you if nobody else has one. Crimes against people because they're Jewish. Is that something that is on the rise?
It is. There is questions about the accuracy of reporting, and so there's movements to work with other religious-based groups on their reporting numbers. Jews continue to be the largest targeted group of religion-motivated crimes.
To what do you contribute that?
There is a general rise in anti-Semitism right now in the country. We just recently released our annual audit of anti-Semitic incidents, and we saw a 60% increase in anti-Semitic incidents. This is not specifically hate crimes. This could be harassment, vandalism, assault, 60%, almost a 60% increase nationwide.
To what do you contribute that?
We don't know. We're looking. We're seeing a lot more anti-Semitic incidents in schools, and I should say not just anti-Semitic incidents, but bias-motivated incidents in general. We're seeing young people having issues, questioning kind of how to express themselves and discover and learn, and we're seeing people copy the behaviors they're seeing from adults around them.
As you look, as you say, what do you see the possibilities for being for the rise in that anti-Semitism?
We're still looking into it. So we also do an annual survey of anti-Semitic attitudes, and so that will be coming out soon, and we'll have a little more information about kind of diving into the depths of why people are behaving anti-Semitically and kind of expressing themselves more. We don't have that data yet, though.
But you're not willing to tell me now what those possibilities are, correct?
I don't know what they are.
Thank you.
Sure.
Appreciate it. Appreciate you being here today. Thank you very
Absolutely.
much.
Thank you.
Is it Tanya Diddy? Miss Diddy, come on forward. Good to have you with us today. Did I pronounce that correctly? Okay. Thank you for coming. Please tell us who you're with, and happy to hear from you.
Good afternoon. My name is Tanya Diddy. I'm the State Director for Concerned Women for America of Georgia, and appreciate the opportunity to testify. We are opposed to this bill, but I would like to make a comment just kind of to what you were speaking of, Representative Willard. I had the opportunity, I was a high school teacher, and I cut my teeth teaching in a school that was primarily African American. And I will say, growing up, we did not have a lot of history of the civil rights movement, but I've got my history by being in that school. I was groomed by the principal who went through the civil rights movement. I wanted to be a principal. She was willing to take me under her wings. The first time I ever heard of Congressman Lewis was when he came. I was in Fort Worth. He came to Fort Worth to speak at an event for students, Black History Month. So I gained just a tremendous amount of respect for what went on during the civil rights movement. So that's why it's hard sometimes to testify against a bill when it sounds like you are going against some folks that really had that struggle, but fought hard to overcome what we went through in our country up through the 60s. But that being said, I just want to give a short testimony on why we oppose this bill. This bill might sound good on the surface. I don't know anybody that is for hate crimes. It violates, though, the constitutional concept of equal protection under the law. The 14th Amendment of the United States affords equal protection to every citizen under the law. This bill would create a multi-tiered system of justice in which some crime victims' cases are taken more seriously than others. Under a hate crime law, an elderly man who is mugged for a Social Security check is told essentially that what happened to him is less serious than what happened to another victim whom the government has deemed a preferred victim. This is simply a denial of equal protection that all crime victims should enjoy under the Constitution. While the intent-based evaluation of murder examines intent and treats all victims equally, hate crimes requires an evaluation of the criminal's thoughts and treats victims differently based on their identity. I will say that I certainly respect those that have worked in GBI and prosecutors and defense attorneys. I am not either of those. But it really sent chills down my back when I heard that, okay, I'm going to go out and I'm going to look at your Facebook pages, your social media, maybe somebody that I stood across the street with in Liberty Plaza, that those things are going to be able to be evaluated on whether if there was a crime that I supposedly did against someone, that you're going to go through and you're going to flesh through all of my social media. And again, this is just even crime on property. That is not the America that I grew up in. I would like to speak just to the statistics very quickly, and then I'll conclude. All hate crime laws attempt to read people's thoughts, motives, and attitudes, violating freedom of speech by silencing and punishing all viewpoints. According to some experts in the law, some jurisdictions have defined hate as not just physical acts, but verbal acts as well. In most cases, so-called hate crimes are intimidation and name-calling rather than physical acts of violence. The FBI statistics show that there was 6,121 hate crimes reported in 2016. Of these, 1,577 were listed as intimidation, 1,458 were listed as simple assault, 684 were listed as aggravated assault compared to the national statistics that were showed at 803,000 aggravated assaults against persons. This is 0.00085% of all aggravated assaults. So the data just to me is a false narrative. So we again oppose this because we do not believe that Georgia needs to be getting into the idea that we are going to go out and look into the thoughts and minds of people to have enhanced penalties on crimes. Thank you so much for your time.
Thank you. Any questions? Ms. Hanson.
Good afternoon, Ms. Vinnie. I'm looking at your Concerned Women for America website, and one of the things that y'all list as a priority is religious liberty. And it says CWA supports the God-given rights of individuals in the United States or other nations to pray, worship, and express their beliefs without fear of discrimination or persecution. Does that not extend to violence against them because they are related with a certain religion?
The hate crimes that are at the federal level has that religion as listed.
So if it doesn't fall under the federal statute and it's at the state level, then it's okay?
I don't know that I understand your question. Can you repeat the question?
Sure. So you say that, or the website, says that basically people shouldn't be persecuted or should be able to practice their religion without fear of discrimination. And I'm asking you, does that extend to should they be the victims of crime because of their religion?
I don't believe that we need to be categorizing people in the United States. I think that every person under the 14th Amendment has equal protection under the law, and I don't believe that we need to be grouping people in the United States. So if you're asking, because I'm a believer in Jesus Christ and as a religious person, that I would hope that that I would be protected against additional penalties. I'm just hoping that if someone beats me up or rams into the back of my car, that their penalty is treated just basically as under the law, not assuming that they did it because I was a religious person. I just hope that they would be treated equally under the law as I would want to be treated equally under the law.
It also says on your website, support for Israel. The CWA believes that people in the nations who stand with Israel and Jewish people will be blessed by God. We believe that any foreign policy, blah, 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 that's irrelevant. How does one stand with Israel and Jewish people?
Personally, I stand with Israel. Our organization stands with Israel. I don't want to see the rise of anti-Semitic crimes in the United States. I think it's horrible. We stand with Israel. But again, I think and I don't know the law, but I do know that you go before the judge or in a court, they have flexibility within the courts to render harsher punishments if needed. But again, we believe in the 14th Amendment, equal protection under the law.
Thank you.
Thank you.
Representative Smyrie, we have a sign-up list, but your name is not on it. Did you want to come speak? I'm not asking you to. I just didn't want you to know.
Please.
Come on up front right here. I thought you had post-traumatic stress disorder from being in Judiciary.
Last time I was in this room, I was the governor's floor leader. And Rusty Sewell was the general counsel. I saw him in here somewhere, so it seemed like deja vu. But
I don't look like Charles Thomas.
No.
Thank you, Dean Smyrie, for being here
today. Thank you, Mr.
Go
Chairman. I just want to say that I just want to come and thank Chairman Willard, and also thank Representative Hanson, who had House Bill 660, and Representative Karen Bennett, who had House Bill 663. I am the second signature on both of those bills. And early on, Chairman Willard called me maybe a couple of months prior to the session and stated that that was going to be a possibility of a hate crime bill. And being that I'm not a lawyer, but being that I have been involved in this process, he wanted me to follow the information that was given to him, and he was working with the Anti-Defamation League and other organizations, the prosecutors and others, to come up with a bill that we could present to the Georgia General Assembly. I guess we're going to wait to Georgia to be the last state without a hate crime. I hope not. I hope we have some leadership. Right now, we're one of the 5 states without it. And hopefully we don't wait and wait and wait until we're the only state without a hate crime bill. So all the nuances of it, you know, I've delved in, I've drilled it and looked at it, and I think you all are the persons to come up with the appropriate language and what should be included and not included. And I didn't want to address that, but I did want to come today to say that I support some legislation, and I'm here to support Chairman Willard in his effort to get something before the members of the General Assembly. And he assures me that this is the way to do it. And I supported Representative Hanson. I supported Representative Bennett. Both their bills I've read over, and recently I had a chance to sit with That's a private number right there. I don't know how they got that. Yeah, that's not supposed to be a legal.
sold.
Yeah, yeah.
You-
Somebody has
Been
it.
sold and distributed
Yeah,
now.
somebody has it. But
You were sought
that's
after,
the
Mr.
that's the
Chairman.
rationale, and that's my reason for coming. And I just wanted to come in that fashion. But I did, Mr. Chairman, if I could, Representative Bennett wanted to say something. And,
I've got her on the list.
Okay,
You just
she's-
weren't on it, that's why I asked
Okay,
you.
she's on the
Yeah.
list, and then I'm just here to, there were some issues that reference gender identity, and and Representative Bruce and I have discussed the political inclusion issues because of the freedom of speech aspect and how people are labeled and what actions are derived thereafter. And I've assured him I think that covers this. So with that in mind, I want to thank y'all for allowing me to have the opportunity to come. I leave it up under the wishes of the members of the Judiciary Committee, who I admire all, because in my opinion, this is one of the hardest working committees in the General Assembly. And y'all spend countless of hours in this room dealing with all types of issues. And I've had the opportunity to see some of the good work you've done. So hopefully we can come up with something, some compromise, where we can get out of this committee and get it on the floor of the House and debate this issue, and give everybody their say as to what direction we should go in. And I think that's democracy.
Yes.
And that's how you form good legislation, and that's how you form bad, you get the good things in, the bad things out. So that's my little part that I want to impart on the committee.
Thank you, Mr. Chairman. Any questions? Thank you for being here today.
Thank y'all very much.
Representative Bennett, why don't you come on up as well? Appreciate you being here with us today. Come on forward and we'd be happy to hear from you.
Thank you for having me to this committee, and condolences again. And I just want to come before the committee to thank you, Chairman Willard, for finding an opportunity to bring such an important issue and bill to the citizens of Georgia. I won't reiterate what Chairman Dean has said. I want to thank Representative Hanson, and she and I know both we have very similar intentions regarding this legislation. But I'd like to come with a personal story.
Mm-hmm.
Personal story. Chairman Willard, you touched me when you started out with your 1960s experience. Treat everyone as you are treated. I've lived through the terror and the terrorism of having perpetrators of hate come through our communities as a child. Not the 60s, but the 70s. And when one of my classmates were hung in early 1970 in a community, I witnessed that. And then most recently, with the South Carolina massacre, one of my dear friends was in that church, Mother Emanuel. Much younger than I, Chairman Willard, but nonetheless left two darling children behind. And it was articulated by the perpetrator that it was hate. And so I've had a chance to talk with Attorney Scandalakis with the Prosecuting Attorneys Council, who advised, and the GBI director, who talked about hate crimes being terrorism, not just on the intended victim, but a hate crime perpetrated against an entire community. And now I even go so far as to say perpetrated against an entire state when offenses are done just simply out of biases and hate. And so I thank you for your consideration of this most important bill, and I look forward to it coming to the House. So thank you very much.
Representative Bennett, we appreciate you being here today.
Thank
you,
you.
ma'am. Okay. Jane Robbins. Ms. Robbins, welcome. Good to see you. Please tell us who you're with, and we'll be happy to hear from you.
Okay, my name is Jane Robbins. I'm actually not with anybody today.
Okay.
This isn't my organization's issue, so I'm just here as a private citizen from
All
Tucker.
right.
And so I didn't come prepared to testify because this was sort of sudden, but I won't reiterate what Ms. Diddy said, although I agree that there are some serious constitutional problems here with equal protection. But I've got 2 or 3 random thoughts. One, about the South Carolina situation. I've been following that as well. I'm originally from South Carolina, and my son lives across the street from that church. He can hear the singing on Sunday morning. And I would just point out that everybody recognized that as a heinous crime. The jury recognized it, the judge recognized it, and the perpetrator is on death row. So I don't know what else a hate crime would do, a hate crime bill would do to make that any better. And I would point out that as long as we're going down this, in my view, dangerous path of analyzing people's thoughts when they commit a crime, that can be wrong. And I think you were getting at that a little bit earlier. And the most probably noteworthy case that we all knew about was the Matthew Shepard case. And it turns out that everybody just accepted that as a hate crime, that he was killed because of his sexual orientation, and the press took it and ran with it, and it just became a just gospel that that's what happened. And it turns out that maybe that's not what happened. What happened seems to be more of a drug deal gone bad between two people who were former lovers. And so, but that all gets lost in the press hubbub about something like this. So we need to be very careful with that, and especially with some of the commentary that I've heard today, we seem to be having this discussion of whether this particular group of people should be protected under hate crime bill versus that particular group of people, and what we're getting into is government preferred victims. We don't like what you're saying or what you're thinking, and so we're not going to protect you, but we do like what you're saying and what you're thinking, so we will protect you. That's not what the government in the United States of America under our Constitution should be doing. And the final thing I would say is I would point out that in 2013 in Canada, the Canadian Supreme Court ruled that passing out flyers with scripture verses was a hate crime. Now, that's not going to happen under this bill, because this bill is about assaults and battery and that kind of thing, I understand. But it's the first step. And in the environment that we're in, which is getting worse every year, every month, every week, practically, that's where we could end up. So I hope that you would consider that in considering this bill.
Thank you, ma'am. We appreciate you being here today. Mike Griffith. Mike, please come up. Good to have you. Tell us who you're with, and we'll be happy to hear from you.
Thank you, Mr. Vice Chairman. And I'm Mike Griffin. I'm the Public Affairs Representative with the Georgia Baptist Mission Board. And I want to say how much I respect Chairman Willard. We've worked together down here, or worked against each other sometimes, for 11 years. And but I have a lot of respect for you. You're the kind of person that you can work with. You're the kind of person you can talk to. And so, and you and I represent what I think, people are going to say, well, we definitely feel that way about Wendell. We don't know about you. But really, I think what's great in this country is that you and I can disagree with each other, but that doesn't mean I hate you. And we're losing the civil discourse. I mean, you're a tremendous friend to me, and my daughter who worked as my assistant my first year. And with the personhood amendment, all that, it was an exciting time. It wasn't a good time. But nevertheless, my point is Georgia Baptist Mission Board opposes this substitute bill. And when we talk about Georgia Baptist Mission Board, Georgia Baptist Convention, we're connected with the Southern Baptist Convention, which has been opposing hate crimes legislation, the SBC, since 2007, going all the way back from that. But let me just mention just a few things to you very, very briefly here. We believe that all people should be treated with respect and dignity because they're created in the image of God. We also believe that no one should ever be mistreated or physically abused because of their beliefs or lifestyle concerning sexuality. However, we find it troubling, for example, when we see terms like sexual orientation and gender identity, which I know is not in this sub at this moment, because a higher standard of prosecution for certain crimes seems to appear there. Such classifications do not treat all individuals equally. It sends a message that some people are more valuable than others, and as such, crimes against them ought to carry heavier penalties. This type of bill does not treat everyone equally before the law. Now, Time Magazine had an article in it on August the 4th, 2016, and Time Magazine's not known for some right-wing magazine, but the title of the article was Hate Crimes Laws Are a Form of Discrimination. It says the hate crime law movement recriminalizes conduct that is already criminal. In effect, it creates a hierarchy of victims, one based upon the group identities of perpetrators and victims, as long as prosecutors can prove a biased motive. Thus, from the beginning, hate crime laws have simply given us something else to argue about: whose victimization should be punished more severely. They further politicize a law enforcement and criminal justice process that does best when it is perceived as being apolitical and even-handed, not a tool of identity politics. The focus on crime legislation needs to be on the act itself and not on criminalizing beliefs. You see, hate crimes legislation seeks to criminalize beliefs as well as actions, creating in essence a form of thought crime. We believe all crimes, especially where bodily harm has occurred, should be prosecuted and punished to the fullest extent of the law, period. The bottom line here is that the 14th Amendment guarantees all citizens equal protection under the law, and that since hate crimes legislation elevates some victims of violent crimes over others, we oppose the passage of any hate crimes legislation, and we call upon the Georgia General Assembly to oppose such legislation. Thank you, Mr. Vice Chairman.
Okay, I think we have some questions. Ms. Hanson?
I guess my first question is, what group is raised above another group under this bill?
Well, if you are picking out certain individuals of victimization to be greater than others, you have a list of them in there.
Yeah, but what group? Like what?
Well, that's what we're talking about. The special identifications that you have in the bill there.
So, how many of those groups do you fit into?
Well, I fit into a group of a citizen of the United States of America that should not be abused, period. That's what the 14th Amendment is all about. That's that level playing field there. And, no one wants to be behind any motivation that causes anybody to mistreat anyone, and that mistreatment should be fully prosecuted.
Has any hate crime statutes ever been overturned on the basis of violating the 14th Amendment?
I'm not familiar with those cases.
Representative Dreyer?
Thank you, Mr. Chairman. I had a similar question. Are you aware of any court overruling hate crime legislation on the basis of the 14th Amendment?
I'm not familiar with those cases.
Okay. It's because it probably hasn't happened, is what I believe, right?
Well, people can agree to disagree on court cases. I don't know. The principle I'm talking about here, I think, still stands. What we're standing for, and what Southern Baptist has stood for since 2007.
Thank you.
Representative Bruce?
Yes, sir. Do you believe that all of these groups that are outlined in here are currently treated on equal ground?
I don't even know that Christians are treated on equal ground.
That wasn't the question, sir.
And any mistreatment that is unequal that leads to any type of physical violence or mistreatment of a criminal nature must be prosecuted. And we have cases where, we know that we have that judges do have some variation on how to deal with those severities, and those are taken care of. And just like the things you just heard a few moments ago, concerns of one thing leading to another, and how other countries we've seen that began down this road, eventually you're down to the fact that if you just write something that somebody else doesn't agree with, it's considered to be hate. I mean, it was constantly, you want to see some hate, wait till probably my Twitter feed after I finish today. You'll probably see it.
With all due
I mean, that's just wrong. They ought not do it, but I don't think there would be.
But with all due respect, with all due respect, sir.
Yes, sir.
The question was, do you think that the people that are outlined, or the groups that are outlined in this legislation, are currently being treated on equal ground?
Nobody's being treated perfectly,
okay,
including the religious people,
okay,
which would include my side. That's just part of life. And then when it raises to a criminal level, it needs to be dealt with.
Okay, well, if you believe what you just said, that the religious, because this bill addresses,
it has it in there.
So you would be protected.
I'm already protected.
Okay, but
because of being a citizen.
Well, you're fortunate that you believe that, but there's other people that don't believe that they're protected.
And people disagree with each other.
Okay.
On that.
This
I mean,
will be
that's respectable.
This will probably be a question that you'll never answer, so I'm gonna stop asking
Okay.
it. But the reality is that, you know, in this country, there are groups that have, it's been very clear, you know, that they have not been treated equally. You know, again, you know, some people pointed out their own personal experiences, and I remember my personal experience of being in school, and my school happened to be up on top of a mountain looking down on the James River, and I saw at least 3-4 times a week the Ku Klux Klan down there burning their crosses and wishing that some of us were there. So I honestly don't believe that everybody's been treated equal in this country. I honestly believe that they're not currently being treated equal in this country. So I welcome an opportunity to do exactly what you said, equal the playing field. And I think that's what this legislation is intended to do. Thank you very much.
Representative Beskin.
Thank you, Mr. Chairman, and Mr. Griffin, thank you for coming today. I understand your concerns about the 14th Amendment and equal protection, and I think you've said that you think all crimes and all people should be treated equally and none are more equal than others. So certain types of crime should not be penalized more than others because of the type of the victim. But would you change that opinion if you knew that the current statutes already do provide enhanced protections for certain types of crimes? The aggravated assault 16-521 provides an enhanced penalty for someone who commits aggravated assault against someone over the age of 65. Public transit vehicle, cargo in transit, firearms on student or teachers, past or present spouses, intent to rape a child less than 14, and there are others. So we already do provide enhanced penalties.
And there are reasons for that, yeah.
Right, okay, so it is your understanding that this bill we're considering today is adding additional types of protections, but to a framework that's already there.
To some extent you are, definitely. I understand that.
Okay, thank you.
Thank you, sir. Appreciate you being here today.
Thank you. Appreciate it.
Good to see you.
All right, Chief. Okay, Paul Smith. Mr. Smith, please come forward. Happy to have you today. Welcome, and please introduce yourself to the committee.
Thank you, Mr. Chairman, Mr. Vice Chairman. My name is Paul Smith. I'm Executive Director of Citizen Impact. We represent churches and Christian schools, other Christian ministries here in Georgia, and we do oppose this legislation, and I'll reiterate what some of my colleagues have said who have also opposed it. It's hard to do. It is hard to hear about terrible crimes committed against people, and no one believes that anyone should be a victim of a crime or should be targeted because of who they are. That said, I'll just make one point, because I know we've been here a long time. I don't believe it's the intention of the chairman or the authors of the original bill, but I do think that there would be unintended consequences of this bill. And the comparison I would use is the federal statute known as the Johnson Amendment. The Johnson Amendment prohibits nonprofit organizations from endorsing candidates. And there are groups who do not like what churches believe, namely certain atheist groups, who will send letters to pastors during political seasons and try to threaten them, intimidate them with losing their tax exempt status, try to silence them from engaging in any kind of political speech during those seasons. I believe that, again, not the intention of the bill, but that it could easily be used by people, groups who do not like what our churches believe, to try to silence and intimidate and threaten them in much the same way that the Johnson Amendment is used. So that's really the only point I wanted to make.
Thank you for being here. We appreciate you
Thank
coming. Mm-hmm. Dave Baker. Mr. Baker, good to have you today. Thank you for coming. Please introduce yourself to the committee and who you're with, and we'd be happy to hear from you.
Thank you, Mr. Chairman. I'm Dave Baker. I'm Executive Director of Faith and Freedom Coalition of Georgia. We're dealing here with a criminal bill in front of the Civil Committee this afternoon. Mr. Chairman, we've known each other a long time, personally and professionally. I have the greatest respect for you and this committee. I would ask you, though, please don't bring up this bill this way. Representative Hansen very ably presented House Bill 660 for, I believe it was a subcommittee, and I believe Representative Bennett as well on hers. Y'all were here till 1:30 in the morning last week on crossover day, getting bills through that had already been vetted through the committee process. And, you know, to get that done, and I'm sure there were a lot of other good bills that didn't make it this way. This is a very important issue, and I think it should be debated. It should be heard, but I would ask that it go through the committee process and rules committee and all that to get to the floor, and I say that with the greatest respect. If I may speak to the product, I won't talk about the 14th Amendment. I think y'all have heard that enough. No one should be the victim of a crime, have to suffer being the victim of a crime based on their race, their religion, their sex, their national origin, or their sexual orientation, or any other category. But I think the way to deal with that is already that judges have discretion in sentencing for the underlying crime, and there's almost always a range of penalties, and that where there is animus against a victim because of any of the foregoing reasons, that can be an aggravating circumstance and lengthening sentences. So I think we already have a mechanism to deal with that. And I thank you all very much for your time and your consideration.
Okay. Mr. Baker, thank you for being here today. We appreciate you coming. That is the completion of the list that we have for people that have signed up to testify as to the bill. So we will bring the bill back to the committee. Mr. Chairman, do you have any comments before we begin our debate?
Just a short statement. I want to respond to Ms. Baker that this is done within what is the existing rules of the House. We're not breaking any rules. I know. And we also consider criminal bills in this committee, so it's not unusual for us to have a bill that addresses criminal sanctions. I think we've heard some great comments. I'm very appreciative of everyone taking the time to come before us and express their opinion. We're going to go into hopefully a process of considering the bill, Mr. Chairman, and in doing so, I hope that the main thrust of what we're trying to accomplish here carries through. As was said, I think it's very true. We are now one of 5 states without recognizing certain conduct by people rises to a different level of intimidation and fear that should be also recognized in the statute that we have before us as a way of trying to address that issue. So I'm supportive of the bill. I hope the committee will give good consideration to it and we can pass this on to rules.
Thank you, Mr. Chairman. Ms. Hanson, did you have something you wanted to say before we begin our debate internally on the bill?
And I want to comment to Ms. Hanson.
Okay.
She has worked tirelessly. I watched her on this bill, with her bill, helped her with it. Unfortunately, it didn't go as far as we wanted to, but I don't think because her bill did make it that we stopped considering this important issue in this state. And I hope to, and I say here, thank you, Ms. Hanson, for the work you did. It was tireless. I know how much time it took of you, and I think you did an outstanding job, and I appreciate it very much.
Okay. Mr. Holcomb, did you have a comment before we begin debate on the bill? Okay. Ms. Stevenson, did you have a comment before we begin debate on the bill? Okay, go ahead.
Won't last long. First, I want to thank the chairman for bringing the bill and for the authors on 660 and 663, Megan and Karen, on the bill. Mm-hmm. I don't know that there has been any constitutional case that said on a hate crime anywhere in any state that has it, that they brought up a violation of the Constitution, excuse me, by the equal protection of law. I have not seen that happen. But what I will say is that even a few years ago when we looked at the method in which we did kidnapping, if you can recall, and we moved it from where it wasn't put in a different area, but it is the same as what is being done with hate crimes. I do not believe that hate crimes is set forth to come up with different ways to treat those who are the ones who have committed the hate crime. Now, we may change some of what we're looking at today, but the idea that we believe that we shouldn't have a hate crime in the midst of what's going on in regards to race, gender, on and on is what we name. So I believe that we should just move forward, look at it, debate it here as we sit, and then make sure that we have a hate crime that can be utilized in Georgia like the other states that we are close to.
Thank you, Ms.
Thank
Stevenson.
you. You're welcome.
Now, if you wish to make a motion regarding the bill, please, Mr. Chairman, you have something you want to say?
I'd like to make a motion on the appropriate time.
Mr. Chairman, go ahead, now would be the appropriate time.
Thank you. Mr. Chairman, I'd like to move for the approval by this committee of the House Committee Substitute, Judiciary Substitute, to Senate Bill 373 as presented.
Ms. Hanson?
Well, I did want to say something, but I kind of got out of turn. Thank you, Mr. Chairman, and thank you, Dean Smurray, for all of y'all's leadership and mentorship on this issue. It has been something that I've been working with ADL and others for quite some time, almost a year now. But I do appreciate you moving this ball forward and continuing this discussion. The only thing that I was going to offer an amendment.
Let's do it this way. He needs a second for his motion. How about you make that then? Okay, all right. So now we have a motion and a second, and at this point, the chair will entertain discussion regarding the bill and obviously amendments if somebody has one. So if you want to press your button, we'll try to do this in an orderly fashion. Ms. Hanson? No, you're not. You're fine. Now would be at the time. Well, let me do this first. What I want to do is I want to see if anybody has comments generally about the bill, and then we will move to a position where we'll take amendments. So, Mr. Welch, did you want to be recognized?
Thank you. Just wanted to ask a few questions just to the committee, and maybe some guidance. The way I read the bill, if there is religious discrimination or if one of these acts, whether it's an assault or an attack on one's property, is based upon one's religious beliefs, then this would increase the penalties anywhere from being the 1 year minimum to a 3 year minimum or 2 year minimum, depending on the statute. Does that not afford greater protections for those people of faith from being targeted for malicious acts by individuals? And so it's just kind of a question to the committee and to the chair. That's the way I'm understanding this with respect to the religious aspect of the list of groups or organizations.
Mr. Chairman, did you want to say something?
Well, I think what we talked about, and I'm not sure if you heard the time, and Mr. Scandalakis, I think, addressed it quite well. That is, you do have first underlying crime. I can dislike you and say bad things about you, but until I physically do something to you.
You do that a lot.
All the time. But until I do something physically to you, I've not really expressed that hate in the fact of committing a crime against you. So once that crime is committed, underlying crime, then you could have the enhancement by the fact that I've expressed in my words, conduct, otherwise, that hate toward you or whatever group you belong to. I don't know if that answers your question, but
No, you're
was
saying
carried.
two-step.
Yes, sir,
One
it
is that
is.
there has to be the underlying
Yes,
crime committed, and then
That's right.
the enhanced penalty as a result if this was intentionally done as a result
As a
of
factual
one's
issue.
religion,
Right.
or race, or any of the listed items.
Yes.
And then the question to the author also is, I noticed that throughout the bill, you have used the word intentionally, where intentionally selected is the phraseology that's used. I did not see that with respect to sections 1.1-6 and 1-7. In those enhanced penalties, it is just if such property was selected. And I
Yeah, those are property crimes. I think, are they not? Yeah.
Yeah, aggravated well, 1-6 is criminal damage to property,
whereas-
and 1-7 is criminal,
right.
yeah.
And I don't know that you have to show intentional where you, say, burn down the church. is the fact that you are you painting a swastika on a synagogue as part of damage.
Well,
I think the very fact that it happened, that would be something, again, going to the action itself as constituting the act of hate.
So,
and let me add to this.
Yes.
It was the drafters of the Legislative Council in leaving that phrase out on both of those, not so much the author.
And that has me a little concerned, because I appreciate the fact that the word intentionally is here, because I think that there needs, if this bill is to move forward, it has to have that very high burden of proof standard that there is an actual intent to cause that action because of this, and that's absent from these two property provisions, and there may be a reason for that. I don't practice in the criminal section.
Yes, sir. I'm looking at Ms. Beskin brought up the statute itself, and of course the statute does go to the description of knowing and without authority, or as being the basis for that crime being prosecuted. So I think maybe the drafter, recognizing that language as to criminal damage to property being knowing and without authority being the underlying action, the federal did not have to bring into intentional here.
And I appreciate that, but it's still we're still selecting, in that case, they're still selecting the property. There has to be an intentional, in my mind, there has to be an intentional selection of that property based upon one of those categorizations. So a conscious decision that I'm going to destroy that particular property because of one of these groups. Knowing destruction of the property is one thing. I intend to destroy it, but whether or not I'm doing that because of one of these groups is different.
And I think what you have, the language was selected because of these perceived things. So you have the intention by the fact they selected that particular property, like as I use the example, they burned down a church, or they painted the swastika on the synagogue, or they bombed the temple. Those are showing the intent as to that specific selected property.
And then that's all I have right now.
Okay. Ms. Oliver, did you want to get on to that discussion?
I was going to add, if I may briefly, I'm really following up what you said at the very end. If I punch somebody, but I have to commit a crime, then I have to prove that I did so because they were Jewish. But putting a swastika on a synagogue does not require proof. If you put a swastika on my Episcopal church, you might have to figure out some way to prove some context of the statute, but a swastika on a synagogue does not require proof of intent. It is intentional, the specific swastika, the specific building. I think that's
What about
consistent with
burning a Jewish person's car?
I think you would have to prove the context of how the perpetrator knew it was a Jewish person's car, and somehow that was in the context of an expressed hatred of them as the group they were in. There's no way that a synagogue could be anything other than identified with the Jewish people, the Jewish group.
I'm talking about the cases that are not, which is what Chairman Fleming is raising.
I don't think a prosecutor would have a pretty difficult burden, I think, of proving that a swastika on the Episcopal Church was against a Jewish person, I think.
The chairman, I think, has pointed out that on line 69, for example, it says, if such property was selected because of such property owner's actual or perceived religion. Mr. Chairman, was that the point that you Mr. Chairman, was that the point you were about to make?
Yes, sir.
Line 69 says,
I think you could add intentional there, but adding intentional doesn't make a better statement of the law, because the conduct shows the intention.
That's why I'm asking to understand that better.
Yeah. Okay.
Hold on one second. Okay. All right. Further discussion before the chair accepts a motion. Ms. Oliver, did you have no further discussion? Ms. Hanson, you told me you wanted to make a motion. Well, let me back up. We already have a motion to pass, and you seconded it, and then I stopped that before discussion. So, any further discussions before we begin to the chair accepts amendments, proposed amendments? Okay. All right. Now's the time for proposed amendments. Ms. Hanson, did you have one?
I do. And you told me, Mr. Chairman, how you think the cleanest way to do this is, I guess I'm just gonna do one at a time. I would like to add gender to the list. So basically on line 22 after homeless status, I would add gender. On line 32.
Well, let's do this. The chair understands your intent. You want to add gender in each place where it is lacking in the bill. And I think Legislative Council, you understand the intent as well. So I think that we could vote once in total on that. I don't think we have to go through each one. So your amendment would be that in each situation where a person's status is mentioned, that we add the word gender, and I think the language is the same on all. It would come after, as you mentioned, homeless status. Does everybody on the committee understand Mrs. Hanson's motion? Is there a second?
Second.
There is a second. Discussion. Miss Oliver?
Mr. Chairman, I think the lines are line 22, line 32.
Yeah, let's counsel indicates he's got it.
42, okay.
Yeah, he said he understands what
Okay.
the intention is. Now, discussion on Ms. Hanson's motion. Ms. Hanson, did you have anything further to say on your motion?
No, I think I made my.
Okay. Any other discussion regarding Ms. Hanson's motion to add gender? Okay. If there is no further discussion, the chair will call the question on Ms. Hanson's motion to add gender. All those in favor, please indicate by saying aye.
Aye.
All those opposed? The motion carries. All right. Is there other amendments at this time? 16, is that you, Mr. Dryer? Okay. Mr. Dryer?
And I am certainly very hesitant to slow down this process in any way, but I would like to also...
Then the chair will allow you to stop now if you want.
I would like to, let me strike the first part of my statement. I would like to move to add a gender identity to every situation in here where we're identifying classes of individuals.
Legislative Counsel, Ms. Talbot, my suspicion would be you understand his motion and you want to put it in all the same places we just put gender, is that right?
Yes, Mr. Chair.
Okay, gender identity, okay. Does anyone not understand Mr. Dryer's motion? If you do understand it, I'm going to ask for a second to see if we discuss it. Is there a second?
Second.
There is a second. Okay, now we are going to discuss Mr. Dryer's motion. Mr. Chairman?
Let me ask Mr. Dryer, I'm not opposed, I'm just trying to find where there comes out a difference between when we have sexual and sexual orientation, what is being added by putting gender?
Gender
identity.
Gender
yeah.
identity. Yes, Mr. Chair. Thank you for asking. Gender identity, in my understanding, would be what someone perceives themselves to be. So if someone is presenting themselves to the world as a woman, but they might not have all the characteristics of a woman, the gender identity would provide specific protections.
Is that not sexual orientation, what they're oriented to be?
No, so, Mr. Chair, I think sexual orientation would refer to who someone loves and partners with on a sexual basis.
I think, and I'm asking this really as part of the discussion, I believe we have either in the law or certainly in some case discussion, a broad definition of sexual orientation, which includes the things you're talking about. That's why I'm just.
I understand, and looking at the law, that sexual orientation does refer to who someone is attracted to or loves, versus gender identity is how someone perceives their gender to be. So if I were to have someone born with the general characteristics of a son but chooses to wear a dress and other characteristics of a woman, that would actually be someone who could be assaulted because of the way they are dressing.
I mean, transgender type, what you're looking at.
Yes, sir.
And I guess to counsel, are you looking up something where we? Yeah, I'm curious because I'm not saying what you're doing wrong. I thought my term was inclusive of all that.
You know, Mr. I spoke with some experts on it, and that they tended to think that there would be a gap. There would be a gap, and specifically for transgender individuals. That would be the gap that would not be covered by either gender or sexual orientation.
Mr. Welch?
This is, I had the same reaction to the motion that the chairman is having, because I thought this would be covered by Megan's amendment or in the definition of sexual orientation. And I don't know that if we don't have some kind of definition to this, then I think you're opening up a real problem for the prosecution of this provision. And I know this bill is well intended, and I really just would not want to see this bill slow down, hit stumbling blocks, because we don't have that term defined, and we're in full committee, and we're trying to move this bill forward, and then it just not make it.
I guess I'm sorry to be interrupt.
That's all right.
Pardon me. I look at the states that we talked about earlier. I don't know if they've had that as a separate type of classification, and that's what I'm just. We have.
I don't see it in here,
and that's why I'm get back to what is. I know what experts are saying. The experts are not the law, but the law, case law, and statutory law is what we're talking about. And I'm afraid we're trying to find something that may not have a specific definition, but for the fact that there's sexual orientation defined.
Mr. Dreyer, you want to make a comment?
Yes, thank you, Mr. Chair. Chairman Will, we would follow the federal hate crime statute on that. There was testimony earlier that was introduced probably in 2010, gender identity. So I think there's going to be a well-defined body of federal law we can look to if there's not already in Georgia. But it seems that that's been constitutional, and that has been able to be enforced for protections for the transgender population.
Okay. Further discussion, Ms. Hanson? No. Okay. All right. Any other discussion regarding Mr. Dreyer's proposed amendment? Mr. Dreyer?
Yeah, just a final comment on it. Last year there were 5 transgender individuals that were targeted and killed in Georgia, and and knowing some transgender individuals, some of the stories, if we had more time to go through them, are very tough. The targeting of individuals because of their perceived gender, heinous crimes. Jeff Graham spoke earlier today about just some of the viciousness of the crimes against transgender population, and I really do think it's one of the most vulnerable groups at this time. And that's all I have. I appreciate your consideration.
Mr. Wells?
What discussions regarding, was this going through subcommittee? Did it go? No. Okay.
Any other comments or questions or discussion regarding Mr. Dreyer's amendment? Hearing none, the chair will call the question. All those in favor of Mr. Dreyer's amendment indicate by saying aye. Aye. All those opposed, no. No. In the opinion of the chair, the noes have it. Any other amendments to the bill? Ms. Hanson, did you have another amendment?
I would just strike political view.
Okay. There's a motion and a second, and I assume, Ms. Hanson, you're talking about just like with these other amendments, all the places that you got that legislative council? Okay. All right. Discussion regarding Ms. Hanson's proposed amendment to strike the words political view in all places that it appears in the same list that we've been working with here. Is there anyone who would like to discuss the motion? The chair hears none, so the chair will call the question. All those in favor of Ms. Hanson's amendment, please indicate by saying aye. Aye. All those opposed? Okay. The word political view then is taken out. You got that, Mr. Legislative Counsel? I got it. All right. Any other amendments to the bill? The chair sees no one else that would like to make an amendment. All right, so we now have the bill in front of us as amended, or by substitute, is that the right word? By committee substitute. Is there any further discussion regarding the bill before we call the final vote on the bill as amended by substitute? Hearing none. All those in favor of the bill as amended, please indicate by saying aye. Aye. All those opposed? No. In the opinion of the chair, well, the chair is going to ask for a hand, the ayes and nays on this one. This is final passage of the bill as amended, okay? By committee substitute. Thank you, Mr. Jordan. All those in favor, please indicate by raising your hand. The bill passes. Thank you. Mr. Chairman, is that all that we have?
I just want to add, Ms. Beskin had to leave earlier, but she said to me to let it be known that she would vote yes for the bill.
Ms. Beskin is in Senate Judiciary handling her bill where I'm supposed to be.
Yep, you're ready to go.
All right, thank you. We adjourn, Mr. Chairman?
We're ready to adjourn.
We adjourn.
Okay.